Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Adam Jarvis, an Alabama construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I would love to introduce the fabulous Adam Jarvis.
Hey, thank you, Ms. Peterson. Today we'll go through the webinar, and you have the ability to ask some questions, and we'll have time to answer those at the end. Don't include your names or company names in the questions. There's no reason to make those public. But here's our agenda for the day. We'll be talking about your contract and some of my recommendations for contract law and how to make your contracts better and more enforceable in court. Securing your lien rights, securing your bond rights, talk a little bit about bonds, lien and bond rules and exceptions, lien law traps to avoid, the right way to exchange a release for a check, and then Ms. Peterson will talk a little bit again about SunRay and the resources that they offer. About your contract, me as a lawyer working with general contractors, home builders, roofers, plumbers, and electricians primarily, that's most of what my law practice is. I love it when they come to me and ask me to help, write or review their contracts. But you don't need it to be real long and fancy. You need the basics for it to be enforceable. The contract needs to be in writing, needs to identify who you are and who the owner of the project is. Define the scope of work as well as you can. I see a lot of real vague scopes of work, and most of the time that's okay. But I think to the extent that we can be expensive when people don't pay the bill, it makes the judges a whole lot happier when we have to go to court and show the court that contract. Certainly it needs to have a price, and get signatures by your owners, guys. I have some roofers that they send out estimates, and if they could just get a signature on all those estimates, I think we could use that as an enforceable contract, and they just won't do it. So please, when you're out there, get signed contracts. Of course, if you're a general contractor or home builder, that's a requirement for your license. And for home builders specifically, I quoted what the home builder regulation is here in the state of Alabama. Alabama home builders are required to use a valid written contract, including an offer and acceptance indicated by the signing of all parties. So, that regulation is a pretty simple requirement. They don't require a complicated contract, but it does need to be written and it does need to be signed, especially by the owner. And what we run into trouble the most is not the contract itself. Usually that's not a problem. Usually when the home builders are calling me, it's for change orders. And I see so many change orders that are by text message. And at least here in Mobile County, there's really no guarantee that a text message change order is going to be enforceable if the homeowner doesn't pay for that change, even when it's been built out perfectly. Sometimes that just doesn't count as the kind of signed writing that the judges around here would like to see. And so, I often create change order forms and try to give them to my clients, and we want them to be in writing. We want them to be signed by all parties. Especially if the construction project is financed by a bank, we'd like the bank to be knowledgeable about the change order before it's performed. And getting a bank signature is a real help. And this is my opinion. I think it's the best policy. Change orders need to be paid before they're performed. The normal construction project, you've already got, you've got under contract, and usually you get paid after things are performed. But with a change order, that's sort of a separate contract with the owner, and it's often outside of the financing that they have for the project. And for that reason, to secure your rights, I really recommend you try to enforce that where you can. Let's see, if your contract begins its life as an estimate and is entitled estimate with an acceptance and an authorization to proceed signature block for the owner to sign, it needs to say it's a contract. I've got a couple contractors that'll do this, and they'll create an estimate, and they'll hand out the estimate, and it becomes the contract when the owner of the property signs the bottom of that estimate. I think that's fine. I think it's perfectly enforceable. You just want to have some language at that signature block with the authorization to proceed that this has now become a contract, and the terms on that estimate are the contract terms. And you know, whether or not a contract is really a contract shouldn't be a close call. And when it says that it's a contract on your estimate in the signature block, then it really isn't. And I gave some example language. Upon signing below, this document becomes the exclusive contract between contractor and owner. Something like that really helps a judge out when a judge is trying to decide, do we have a written contract here? And you know, one of the reasons that that matters a lot is for the Alabama Prompt Pay Act, you have to have a written contract in order to get the interest and attorney's fees under the statute. And so just showing that we had an estimate that had a scope of work, had the price, that you did the work, and that was the price that you charged, you know, that's not enough on its own to qualify for the attorney's fees and interest under the Prompt Pay Act. You need to have a signed contract, and, you know, and it doesn't have to be real complicated, but it does have to be signed. Talking about securing your lien rights, you know, when you finished a project and you haven't been paid, you've got a final invoice out there and it's delinquent, you know, that's the point where, you know, contractors start calling people like me. And whether you file your own liens and ask for your lawyer to enforce them, or whether you ask for the lawyer to file liens for you, you know, either is just fine. But, you know, some of the things, you know, if you're going to be filing liens, it's my recommendation, if you can, to complete the project. You know, I know on some cases where you're expecting to get progress payments and those progress payments are slow or not coming at all, you know, and the owners really breached the contract by not making those progress payments. The thing is, when we get into a courtroom and the court sees that the work was never finished and the owner never paid in full, you know, sometimes the judge says, well, it looks like everybody breached the contract a little bit. Well, that's really not what happened, because, you know, you, the contractor, only stopped performance because the progress payments weren't showing up. I think that's understandable to me, but where you can afford to complete the project, your lien rights are a whole lot more easy to enforce where the project is complete. Now, these would not only be complete, these be free from defects. You know, where there are punch list items, if we're going to put a lien on somebody's property, we really need to clean up anything that's wrong with that project and have it done, you know, free of defects and in a good and workmanlike manner. You know, to me, workmanlike manner is sort of an industry standard. Is it as good as would be expected for the type of contractor that you are in this area? And if it is, then it's good and workmanlike. You know, the thing with lien law is that statute of limitations can be killer. We'll get into that in more detail in a few minutes, but you've got to be paying attention to the statute of limitations period for your unpaid bills. You know, my father is a master plumber, and you know, would bring me these invoices that are a year old all the time and ask me to collect on them. And of course, we can do that on breach of contract grounds, but we can't file liens because he's waited past the statute of limitations. You know, if you're a subcontractor, you know, I like it to be that if an invoice isn't paid for about 60 days, you know, shoot it over to me. Send me an email, send me a copy of it and a copy of the contract. If you've got a direct contract with the owner, you know, you get to about 120 days on an unpaid bill, you know, send it over to me so that we can get those things on the calendar and make sure that we don't miss a statute of limitations period. Of course, if you're a subcontractor or a material supplier, you have a notice requirement before you can put a lien on somebody's property. You have to give them notice that you're intending to put that lien. You have to give the owner notice, and of course, you'd also want to notify the party that owes you the money. You know, usually the contractor up the chain from you. And of course, if you are a subcontractor or material supplier, you have what are called unpaid balance lien rights, that your lien rights only extend to the amount of money that the owner is still holding in their hand and has not paid to the general contractor or home builder up the chain from you. If the general contractor or home builder has been paid in full, then you really don't have any lien rights against the owner of the property. The right person to go after for collection is the contractor up the chain who's holding your money. And so you'll want to check and see, is there an unpaid balance that the owner owes to the general contractor or the home builder that you can see if it's worth filing the lien in the first place. Talk about bond rights a little bit. I don't deal with bond rights very often. Of course, bond rights are for generally public work, but they work pretty similarly to lien rights. I mean, for both liens and bond claims, it's best if you finish the project, that it needs to be free of defects in a good and workmanlike manner. A few differences. Lien rights, began in ancient England. They've been codified in the Alabama statutes, but lien rights are a property right in the land where the project is located for the work that was done. Bond rights are contractual rights. They're not tied to the land in a contract between the owner and the surety, or the general contractor and the surety. The rules for liens are codified in statute, like we talked about. That's Alabama Code 35-11-110 and the ones that follow. And the rules for bonds are usually in the bond document itself. If you can get a copy of the bond, and they tend to be pretty similar to one another for particular purposes, you can see time periods and what information has to be produced to make a bond claim. A couple things that we'll talk about for lien and bond rules and an exception or two. We'll talk about the statute of limitations in a little bit more detail. We'll talk about notice requirements, particularly they're talking about for subcontractors and material suppliers. And then we'll talk about what information needs to go into the notice documents and lien documents themselves. The statute of limitations for lien filing is found in Alabama Code 35-11-215. If you're a prime contractor, you have a direct contractor with the owner, then you have 6 months to file a lien after the last day that work was done or materials were supplied on that project. If you're a subcontractor, you have 4 months from the last day work was done on the project. And for laborers, I've never had a laborer ask me to file a lien. You only have 30 days. Let's see. It's a month or days from what? It's from the last day that work was done or materials were supplied on the project. And so sometimes you want to look at, did you go back out and do punch work? So if we're right up against the statute of limitations, think we might have gone over it. Sometimes I have the contractor go over the calendar, go over to his records for the project and see, is there any time that somebody went back out there and took care of some punch list items that maybe we can get that date, a little bit more time on it to file a lien. Notice requirements. If you're an original contractor or prime contractor, that means you have a contract directly with the owner. You don't have to send notice prior to recording a lien. Now, I usually do. I usually send a demand letter anyway, and sometimes we get good results and get some payments out of that, even though it's not required. But for subcontractors, materialmen, and laborers, you have to give notice to the owner of the property of your intent to file a lien. Now, the statute doesn't say how much notice. It just has to be notice in advance of filing the lien. And so sometimes when time is real quite tight, you'll send that letter giving notice to the owners, and then a couple days later file that lien, and that's good enough. That's fine. What contents need to be in the notice of intent? It needs to be a writing. It needs to be to the owner or the proprietor or his agent. If it's commercial space, I usually send it to the landowner and to the tenant. The tenant may be the person that the general contractor is in direct contract with. and that's fine. I like to send a notice to everybody. The fact that you claim a lien on the land, the buildings and the improvements, the amount that's owed to you, what you did, and that can be as brief as not even a sentence. You know, if it's that you did dirt work, you know, that would be enough. If it's foundation work, if it's roofing work, or if it's electrical work, you know, sometimes we'll go into a little bit more detail about what components. Same things for plumbing, but you don't need a whole lot of detail describing what it was for, but just enough that, generally speaking, a person who reads the notice of intent to lien can see what you're claiming that amount for. You also want to identify who owes the money. You know, and often that'll be, you know, some contractor up the chain from you, or if you're a general contractor or home builder. Well, here we're talking about notice, so it would be a contractor up the chain from you. I send it certified mail, and I also send it normal U.S. mail. But you certainly want to have certified mail, and I recommend that you scan on your photocopier the notice and the envelope with postage on it, so you have those for the records. Because it's been my experience that if you can show a judge, here's a copy of the notice that we sent, and here's a copy of the envelope with the certified mail, you know, stickers and the return receipt and the postage on it, you know, there's no question that was mailed. Nobody calls that into question. More lien and bond rules and exceptions. You know, your lien amount, the maximum amount, if you're a subcontractor or a material supplier, normally is the unpaid balance remaining in the hands of the owner or proprietor that is owed to the original contractor. And so you as a subcontractor, material supplier, normally only have lien rights up to the amount that the owner has not paid the home builder or the general contractor. You know, the exception to that is that a material supplier can send a notice that they may be putting a lien on the property for the materials that they're going to deliver before they ever deliver any materials on the project. If they send a notice that complies with the statute, and that's on this page that we're looking at right now, then they're not limited to an unpaid balance lien. The material supplier can have a full price lien no matter whether or not the owner has paid the general contractor in full. But they've got to send that notice before furnishing any material. The notice goes to the owner or his agent. In my recommendation, in commercial space that's leased, I would send it to you know, the tenant who you might be in direct contract with, or who the general contractor might be in direct contract with, and the owner. It needs to be in writing, and a certain specified material will be furnished. We want to specify to the extent that we can what is going to be furnished and the prices that they'll be furnished for. And then if the owner does not object to having received that notice, you'll have lien rights that are not for the unpaid balance that the owner is still holding and owes to the general contractor, but for the full amount of the materials that you delivered. And so at the very bottom of this page, I've quoted the statute and what that notice needs to look like. If you basically just put that on a piece of paper and mail it to them as a letter from you to the owner, that'll be good enough. The time for filing suit to enforce a lien is 6 months, and that's 6 months from the date the entire balance is due. You know, when we were looking at time for filing liens, we were looking at the last date materials were done or work was done on the project. But here we're looking, there may be a grace period on the invoice, net due 30 days. What day was the balance due? 6 months from that date is when we need to file suit to enforce that lien. You know, my recommendation is don't wait around. You know, file the lien, give notice to the owner and the general contractor that you filed the lien. A week or two later, if a check hasn't shown up, go ahead and file suit so you don't get close to missing that statute of limitations. the timeline for filing a bond claim will usually be in the bond, but generally speaking, you have any time before 1 year after the general contractor is paid in full to file a bond claim, and that has been for every one that I've ever been involved in. Let's see, notice requirements. You know, if you get a copy of the bond document, it'll say what you've got to do. But usually you've got to, by certified mail, send a copy of the bond claim to surety, the owner, general contractor. And this is my opinion, any subcontractor up the claim from you. And if you know who the bank that's financing the project and the architect on the project, I'd send them a copy as well. But the contents of the bond claim are the same as what would go on a lien. Let's see, traps to avoid. You know, don't file liens when you don't have valid lien rights. If you have not fully performed the contract, there better be a good reason if you're going to put a lien on somebody's property. If there are still uncured defects in your work, that's going to mess up your right to enforce a lien. Pay attention to statute of limitations. Make sure you have the right license. It's incredible how often we have, Georgia and Indiana and Florida contractors coming to Alabama that aren't registered with the Secretary of State and don't have an Alabama general contractor's license or an Alabama home builder's license, and think they can do work in Alabama and enforce it. And usually, no matter how much they spend on that work, it's totally uncollectible. They don't have an Alabama license to do the work, and it really doesn't matter that they were working under another contract. If your contract for commercial work is more than $50,000, you have to have an Alabama general contractor's license to enforce your invoices for that work in court. And then, you want to get the details correct on your lien document, because if you get them incorrect, and then the statute of limitations passes, there's some questions about whether or not you can amend it. As I said before, don't wait around to file suit and miss the statute of limitations deadline, because then you've just spent money on the filing of the lien, and now you've got to spend money to release the lien, and it's as if you never did it. So pay attention to those statute of limitations. Here I've given an example that you can read, but I think we're a little bit over on time, and so I won't go through all of that. The right way to exchange a check, in my opinion, if everybody's local, I like to exchange releases for a check in person. I know that takes a little bit of time and costs a little bit of money, but I think it's a good idea to, especially if you're doing it at a title company, to go there and and hand them a check in person, or hand them a release in person and get that check. If at a distance, I don't like to show them the release until I know that everybody has their documents ready. So we'll talk over the phone, and I'll say, I've got a release sitting on my desk. What about a check? And if the other side says, I've got a check sitting on my desk ready to mail to you, that sounds great. Then I'll say, well, I'll go ahead and send you a scan of this release. Can you do the same for the check and send that to me? And then before you mail it to me, could you send me a scan of the envelope so that I can check in advance and make sure you've got the address right on the envelope, and particularly send me an envelope that has the tracking information on it for me to take a look at and make sure it's all correct. And if both sides do that, I've not had any trouble exchanging checks for releases when we're able to check the address and get the tracking information on the front end. And guys, if you have any questions, I'll be happy to answer them.
Well, thank you so much, Adam. That was incredible. You did a really great job with your webinar. There was a lot of really, really good information and little gems and nuggets of thought for us to consider. I do have a question that came through. It says, can I file an Alabama mechanics lien on a condominium project?
Yes. Yeah. As long as the condominium project is not owned by the state, if it's a private condominium, there's no reason why you couldn't file a lien on that.
All right, wonderful. Would that be filed against each individual homeowner, or would that be filed like against the condo association?
So if your contract is with an individual unit, then you'd file with the legal description of the deed for that unit. If your contract is with the owners association, then you would file against everybody. It would sort of depend on the contents of what your contract says.
Okay, perfect. And then how long is another question that came through, I apologize. How long is my lien effective for? Like after you filed everything on time, how long is that lien effective?
Yeah, so the lien is effective until the deadline to file suit is reached. So the lien is good until 6 months after the entire indebtedness is due. And on that date, you need to file a lawsuit, and that keeps the lien effective during the pendency of the lawsuit. But if you fail to file a lawsuit 6 months after the entire indebtedness is due, you can't execute on the lien anymore, or not execute, you can't enforce the lien anymore because you didn't file suit. You missed the statute of limitations, and you need to release that lien.
Perfect, thank you. I think that's all the questions we have that have been typed in. If anybody does think of a question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions as soon as we can for you. Adam, can you go to the next slide for me?
All right.
All right, so who is ready to win a gift? We are testing your knowledge. If you are able to answer these questions correctly in our chat, we'll go ahead and send you guys a little prize. Here are the questions. Adam has actually gone over some of this information, so let's see who is paying attention. If I'm a supplier, when do I send the Alabama preliminary notice? Take a look. And then the other question is, when is the deadline to file an Alabama full price lien claim? So let me see if you guys can answer those in the chat. Take a look. If you feel like you know it, please put it in that chat. If you have the right answers, we will go ahead and send you guys over a little gift. All right, can you go to the next slide for me, please? All right, so here are some of our SunRay resources that are available to you. Go ahead and scan the QR code. You'll have information and resources to help you guys stay organized, know your deadlines, and secure your lien rights. There's a free project information sheet. This will give you all the tools that you need to know your deadlines, calculate out your deadlines, figure out what those lien laws are, and so many more other resources available. So go ahead and check us out on there. Can you go to the next one for me, please? All right, so SunRay has a new service available. We are now doing SR receivables, so we will have collections for you guys. We're here to help get you guys paid. So if you guys need some help, please reach out and we will get you guys started and get you guys your money. Adam, can you go to the next slide for me? Wonderful. Our next webinar with Adam is July 18th at 3 p.m. Eastern Standard Time. That's don't sign a release unless it says this one thing. So go ahead and check it out. Register for free at sunraynotice.com/education. We'd love to see you guys attend that one and be able to hear what he's going to be teaching us then. Can you go to the next one for me, please? All right, if you guys are able to review us on Google, we do really appreciate it. It helps us get some feedback that's needed. Go ahead and scan that code. It takes about a minute of your time. We really do appreciate all of the feedback you guys can give to us. All right, go to the next slide for me, please. And with that, that is all we have for you guys today. Thank you again to everybody who attended. We hope to see you guys at our next webinar. Thank you again, Adam. You really were incredible. And we hope you all have a wonderful, wonderful sunny day.